Okay, welcome everybody to a technologically difficult third session of our ATAC expert panel discussing the ADCRR prisoner healthcare class action lawsuit here in Arizona. It's a very historic trial. We've just completed week 3 of the trial, and we're about to go into a pause for a couple of weeks until December as testimony continues. And so I am extraordinarily privileged to be joined by our panel tonight. And I will start with Jimmy Jenkins, Arizona Republic reporter, formerly of KJZZ, who has been on this beat and on this story for the last 5 or 6 years here in Arizona, and is the primary source of all information regarding to the Department of Corrections, and has been the single source that has been providing Arizona with information regarding this trial on a daily basis. We are also joined by Julie Gunnigle. Julie Gunnigle is an attorney here in Arizona, a former law professor, and a candidate for office in Maricopa County. We have attorney Stacy Scheff, a civil rights attorney who works exclusively on prisoner civil rights matters out of Tucson, and Billy Peard, who is also a civil rights attorney out of Tucson working on prisoner civil rights matters. And finally, last but certainly not least, is Deb North from ATAC. She is joining us today because we're going to focus this evening on your questions. And so we have gone through and gotten a number of your questions from the last 2 panels and those that you've asked us generally. And so we're going to focus on those questions this evening. We are having technical difficulties. There is apparently something going on with Facebook, so we could not execute live. I'm sorry, Doug?
We have people trying to get in. Shall we let them in?
Yes, please. Let's go ahead and we're going to go ahead and open. We don't normally do it this way, but we're going to go ahead and open up Zoom and let other people join our conversation tonight because of the technical problems that we've had on Facebook. We are then recording this this evening, and we will be posting this video up on Facebook. Hopefully, if Facebook will let us post it after this, and on our YouTube site, which when we post that, we will also supply the link to our YouTube page. So without further ado, let's go ahead and start with Jimmy Jenkins. Jimmy, can you go ahead and give us a summary of this week's events in the trial?
Yes, happy to. So we go back to Monday. It feels like so long ago. We heard from 2 different deputy wardens. There was Lori Stickley, and the other person's name is escaping me. But I remember that there were 2 different deputy wardens, and they both talked about the record keeping process that we see in the Department of Corrections. And there was just a lot of discrepancies. The main thing for me was that there was this issue of how the department is logging out of cell time as if it was given to an incarcerated person, even though they were not able to offer it because of usually of staffing shortages. And there was this kind of weird back and forth about, well, we're doing this because under this guideline C subsection B of COVID protocols, it says we're not going to get hurt in our compliance reporting if we do this. We're allowed to count this. So it was almost like the department was kind of trying to say, well, Centurion staffing was too low to offer, this X program today. So therefore, it's not really on us. So we don't have to get dinged for it in these compliance reports that we have to submit to the federal courts every week. But I mean, it was pretty striking to hear the attorneys say, okay, well, it says here that this incarcerated person was out of their cell for, 20 hours this week, but it was really just 4, right? And they were like, yes, that's true. And, it was just kind of like, I think you could tell the judge was like, wow, really? Like this is, so that was like the records thing was one of the main things that I think we learned from the deputy wardens. Moving on, another big name this week was Larry Gann. He is an assistant director at the Department of Corrections, And he just seems like he has a wealth of knowledge about monitoring the contract, how, all these different provisions in the contract. He's one of the people that seems to be his main job, is he's monitoring this. He's in close contact with Centurion. So it was really fascinating to hear someone who kind of knows both the ADC stuff and the Centurion side of things. He told the court about different things that the department has been doing to try to respond to all the different things that are mandated in the settlement agreement. He talked about how it's been difficult for them to find off-site specialty care providers, which has just been an issue, like one of the main issues since I started covering this case many years ago. That's always been a problem. It's just hard to find like an optometrist in Yuma, for example. So this is one of the things that no matter who the contractor is, they have always struggled with that. He said that was still a problem. Gann also talked about how the sanctioning kind of process works between ADC and Centurion. It's another one of these kind of interesting parts of the contract. If Centurion isn't meeting certain performance benchmarks, the state can fine them certain dollar amounts for those. And if they're not staffing their contract fully, they can get staffing offsets from that understaffing. So he kind of explained how, and apparently since the beginning of the contract, Centurion has paid $17 million in sanctions and $4 million in staffing offsets. And you're thinking they're paying over $200 million a year, or they're getting paid that much. So this isn't a huge chunk of that, but it gave us kind of a clue as to the huge discrepancies that are going on between essentially what they're supposed to be doing and what they're providing, and how many people they ought to be staffing the prisons with and how many that they really are. So it's fascinating to hear from him. We actually learned a lot from him on cross-examination as well. He talked about how he admitted that when there's less healthcare staff, people have to start cutting corners. It can lead to improper documentation practices. He said Tucson and Yuma prisons have really serious staffing problems. And he was also unable to reconcile some staffing reports provided by Centurion with payroll records to monitor their contract compliance. So he's the guy in charge of making sure those numbers match. And he was saying, I do have trouble because of I just have to work with what Centurion's giving me. And it's hard to make those numbers reconcile. So that was kind of a big moment, I think. Then Tuesday was Director Shin. I talked to an attorney today, and maybe the rest of the panel can comment on this, but who told me who listened to Director Shin's testimony, he said, you don't want your client to present two different ways, to their attorneys and then to the opposing counsel. You just kind of want them to be the same genuine person. And I thought that Director Shin was very good under direct examination from the state, from the defendant attorneys who called him, talking about a lot of the things that, painting the department in a really good light, doing what he was there to do, kind of really going on at length about different projects that have been happening in the prison. I think notably, he said this a lot publicly, that he said, he's been in the prisons since 1991. He started as a corrections officer and has been in a lot of different staffing positions in the federal prisons. This is his first time running a state system, but he said several times, and he repeated it again, that this is, the hardest thing he's ever done in his career. And, when we think about all the things that were going wrong before he showed up here, I think that's important to remember, is that, that he was introduced to a seriously challenged department, and then COVID hit. But of course, there's room to critique the way he's responded to all these things. But he readily admits frequently that this was a really difficult prison system to come in on. However, he spoke glowingly of Centurion, who is one of the reasons that we're all here. They're not delivering properly on the contract. And he just had a very positive read on what they had done. He kind of talked about how a 99% recovery rate from COVID was exceptional results. So just painting things in a really good light. On cross-examination, he admitted that, staffing shortages were having an impact on the delivery of care. He talked about how the costs for the department, healthcare costs, have doubled while the population has gone down. He said the state currently spends about $7,700 per prisoner per year on healthcare. But he confirmed that there was like half of the vacancy rates in different prisons, depending on the day. Instead of staffing is a really severe problem. And then at the end, so he was being kind of not obstructionist, but he wasn't really giving the plaintiff attorneys who were trying to impeach him anything really to run with. And then at the end of this testimony, Director Shin said that he believed that the incarcerated people actually have great access to healthcare, and that he said they often have greater access to care than I do as a private citizen. And I just think everything that we've heard, that was a really stunning statement for him to make. He also boasted, again, as he has publicly several times, that being in an Arizona prison was one of the safer places to be during the pandemic. And so that was the way I was kind of left with, there wasn't really much coming out of it, but then the way the testimony wrapped up, that sentiment really, I think, was striking for a lot of people, especially since we've been listening for weeks now about all the challenges that people are facing and lives lost, et cetera. So it just seemed like kind of a ridiculous comparison to make. Then let's move on a little bit further here so we can keep going. I wanted to call out Warden Van Winkle. This was on November 18th. He is the warden of the Florence State Prison, oversees operations of maximum custody units. Remember, part of this lawsuit is about conditions of confinement, because they're like maximum custody conditions. It's not just the healthcare, but it's also that aspect of it as well. So that's kind of why we keep hearing these different testimonies about custody levels and how people are actually confined within the prison. He started off by talking about the way the prisons had changed since the settlement agreement was agreed to back in 2014, 2015. Talked about how some out-of-cell recreation setups were made. He talked about how at Florence, they had a really terrible pest problem, which, a lot of incarcerated people have been reporting, but he actually said straight up, he's like, we live in farmland in Florence, but this is the worst summer I've seen in 22 years. Didn't go into details, but we've seen evidence of pest infestation in previous testimony. So not, I guess, a huge surprise there, but kind of shocking to hear from the man in charge of the place. He talked about the repeated use of force on Rahim Muhammad, because it turns out we're kind of learning more and more and more about Mr. Muhammad's case and what's happened to him as this trial goes on. Turns out that this warden was in charge of the prison while all that was happening. And this is the case of the seriously mentally ill person who was being hit with pepper spray and pepper balls while he was self-harming. And there was an interesting back and forth between Warden Van Winkle and Judge Silver. I thought she really seemed interested in this story. And basically, Judge Silver asked, you've been hitting this prisoner with the gas, the pepper spray every day, more than 40 times. He does it pretty much like the same time every day. Why didn't anyone go back and draw up a plan or get together and say, okay, we can't keep doing this every day? It was just so refreshing to hear someone say that out loud, because watching all this happen, that was just kind of the thing I kept thinking in my head is like, why anything at all? Just literally try anything else at all. But they just kept doing the same procedure over and over every day, which was using force on a person in mental health crisis. So the judge asked that question, and Warden Van Winkle pretty much said that their main job is to get people like Mr. Muhammad to immediately stop harming themselves. And for him, spraying him with the pepper spray is what accomplished that. But, he admitted, and he said that he went to see Churion all the time. They were well aware of him, the healthcare staff, and indicated that, he had done what he was supposed to do, gone to them, asked them for help or guidance, and just apparently no one had been able to do anything. So yet again, that disturbing case study was talked about again. And then finally, today we heard from Dr. Joseph Penn, who was he is a correctional psychiatrist. He is in charge of many of the healthcare or many of the prisons' healthcare in Texas. And he was called as a witness by the defendants. He spoke very glowingly. I've never heard anyone talk this positively about Arizona prisons before in my life, about the tours he had been on and the things that he had seen. And he especially talked about how happy and smiling everyone was at the inpatient care facility at the Perryville prison, which, again, is just totally contrary to other testimony we've heard, other things I've heard about that prison. He characterized the Arizona prison suicide rate as low. Turns out he was talking about the number of suicides per 100,000 compared to other states. But we, in the past couple of years, have actually seen an increase in suicides, almost had a record number of suicides. So that was striking to hear that described that way. And then under cross-examination, and we found out that this expert witness who had been speaking very glowingly about the prison healthcare accreditation system had actually just been stepped down from as chair of that organization's board on November 1st. So he had been going on quite a bit about how great things were in the prison. He also went on and on about how big of a deal it is to be certified by the NCCHC, which is like the National Commission on Correctional Health Care, I think. And again, it was like effusive praise on. And then the attorneys for the plaintiffs got him to talk about how he'd actually just been on the board of that commission. And then we heard more about how Arizona pays that organization to certify their prisons. That organization, we found out, takes money from Centurion to support conferences. They give them grant funding, apparently. So we just kind of learned more about this tangled web of the privatized prison system, the privatized prison healthcare system, how the money kind of all flows together. And it's like everyone, that's supposed to be monitoring each other here has a financial incentive to go easy on one another. So that was just kind of almost a sidebar, but a really fascinating, I thought, tangent to what we've been talking about. Judge Silver asked, so I'll finish with this. Dr. Penn was going through a bunch of medical reports, and he only kind of highlighted one instance where someone committed suicide, where he said there was like a breakdown in communication. But then the judge and the plaintiff attorneys were talking about all these other cases that he had reviewed and not really commented on, where some really awful things happened. And Judge Silver was engaged with that process. At one point, she said, I think it was something to the effect of like, you were not concerned by the lack of communication this person had with a mental health care provider. This wasn't an issue for you. And so I have seen more of Judge Silver leaning in, getting engaged, asking questions, I think showing skepticism. So that is my roundup for you, John.
Outstanding. Thank you, Jimmy. That was incredible. And, I had asked some people, and nobody's seen Director David Shin's moving trucks at one of the gates, so he could move in and get that access to awesome health care that we get in the Department of Corrections. Yeah. So that was a remarkable statement, and it's something that you hear. It's a pretty common trope that you hear a lot of times with people that are not predisposed to caring about the humanity that's inside these Department of Corrections, and so it just shows me that complete disconnect that he has from the reality of the situation that he is charged to deal with. And you're absolutely right, Jimmy, when you were talking that he did walk into a bad situation, but he gets paid a lot of money to handle that, and he's got a lot of responsibility that he is not taken care of, and certainly his arguments would be a little bit more valid had his first acts been to absolutely shut down all transparency into the Department of Corrections as a first order. So I'm not really buying too much of what he's selling. All right. Well, thank you, Jimmy. That was amazing. As always, all your reporting is amazing. There's one other thing too, Jimmy, that that you've pointed out before. You mentioned that Director Shin had his statement too about when he said that prisons were probably the Arizona prisons were safe for COVID and all that kind of stuff. But your reporting has shown that there has been a lot of changes in the death notifications regarding COVID deaths in the Department of Corrections, and those numbers have been, you were on that for a very long time, reporting it almost on a daily basis, and you noticed that there was a regression in numbers reported higher, and then they started disappearing. And so, I'm just wondering when all that's going to come out, and what was behind all of that too. Have you gotten anything else on that, Jimmy, related to this?
Well, there's two columns that they have there. So they put up when someone they think has died from COVID-19 as the main cause of death. They have I think it says suspected and then confirmed, or like something like that. But there's two. Okay, so when it's in the confirmed column, I would have thought they're doing what I'm doing, and they are getting confirmation from either the Maricopa County Medical Examiner's Office or whatever county. You would think, and I thought that's what I had understood to be what was happening at one point. But I was documenting that they were actually removing deaths from the confirmed column. The unconfirmed column, I think, is maybe like when you make an assessment at the local prison or wherever they died, that like, okay, well, we know that you tested positive for COVID, and we're going to write it down as a potential COVID death, and then we're going to check it with the coroner. And I can see how, if that would happen, maybe sometimes then you would go back and say, okay, well, he actually died of some kind of organ failure or something. But what I suspect is happening is that, there's a directive to go back and find, because you'll get these medical examiner reports and they'll say death by pneumonia complicated by COVID-19. That's actually a big one. Or it'll be the reverse, death by, COVID-19 complicated by X, Y, and Z. So I could see someone who was acting in bad faith would go back in and say, okay, anytime that there's like a contributing factor that we can call this, that kind of a death instead, let's do that. And I don't have any proof of that, what's happening. That's just my nefarious,
conjecture,
thinking of what they're doing.
Sure.
But so that's because yes, for a while there, it had gone above 65, 66 deaths, and then it was like down below 60. It's going back up again, unfortunately. But I've never received any confirmation. I do know that in other states, though, that this kind of dashboard is run by the Department of Health. So I think that we are unique in that it's being run by, I don't know who, at the Department of Corrections.
Right.
But I mean, it kind of shows you maybe the lack of just care or concern. I mean, no one seems to care who's keeping track of prisoner deaths and whether it's accurate or not. And it wasn't like a high enough priority to be consulted with like the main health agency in the state, which I think is sad.
Yeah, it truly is. And it's unfortunately, it is something that we have to deal with, and it is something that it comes as an affect of transparency. We don't know what those numbers are changing from. We don't know that. We have to speculate as to what it is, and the reason we have to speculate as to what's going on with the citizens of Arizona that are being incarcerated in the Department of Corrections is because we don't have any transparency at all, and they have openly lied both to the press, the public, and to lawmakers. So this is definitely a rogue organization that we need to use the highest levels of skepticism and scrutiny with. But that leads us into our first question, which is a question. It's a difficult question. It's probably going to be difficult for some people to hear, but it is a genuine thing. And this is actually a question that I have asked many people to answer for me, including some of the members of this panel. Because it's something that we run into with an ATAC when we're going out here to talk to people, talk to citizens of Arizona. So let me go ahead and say this, and this is for the entire panel, okay? So why should we, Arizona citizens, care about the health care or the mental health care or the comfort levels, the condition of confinement levels for people that have committed crimes or broken the social contract and have gone to prison? Why should we care? Who wants to take that first?
Well, I'm happy to talk about this because it's something that I have to deal with in my cases, when I'm going to be going in front of a jury and I have to persuade them that they should care. And my answer is usually that, it's many different things. First of all, they were sentenced for as punishment, and as the department says, for reentry and rehabilitation. So that's what they're there for. They're supposed to be paying their debt to society by being in prison and learning how to be better people, right? So that they don't violate that contract. And so if they go to prison and instead of being rehabilitated, they're actually made worse, and they get out with preventable diseases or, having been assaulted or something like that because of the conditions, they not only are a bigger burden on the taxpayers, but they haven't been rehabilitated. And they're going to come out angry at society and more likely to commit more crimes, because if they're still being ostracized after having paid their debt to society, what choice do they have? If society is saying, no, fuck you, you have no worth, where are they going to get support? So we don't want that to happen. That's presumably the point of the Department of Corrections, rehabilitation and reentry. Next is that if this can happen, if we can basically say all bets are off for somebody who's been convicted of a crime and sentenced to prison, that the prison can do whatever they want to these people, then that means that could happen to you too. It could happen to me. It could happen to anybody on this panel. It has to some people in ATAC. I know Haley Worrell's story is just heartbreaking. Totally innocent of any crime. But her husband was put in prison for, child abuse, which was actually a genetic disease or something that they had not abused their child. Check her out. If you haven't seen the story, it's just utterly heartbreaking. So, if the system can get it wrong, then anybody can fall victim to that. Anybody can go to prison. And then, you can also be denied healthcare for preventable diseases like valley fever or cancers, and of course you don't want that for yourself or anybody you love. So if you don't want it for yourself or your loved ones, then you have to fight for these conditions to be adequate, because if it can happen to them, it can happen to you. So that's my my answer.
And that's absolutely correct. And there's two points that I'll make on top of that, which is there's a lot of confusion. There's a lot of popular confusion. When you're sentenced for violating a felony offense and you're sentenced to go to prison, or you can go to jail on some misdemeanors, but when you're done, the punishment doesn't begin at prison. The punishment is the separation from society. The punishment is the bus ride to prison. What happens at prison is not the punishment. You don't go to prison to be punished. That's not what's supposed to be happening there. You're supposed to be rehabilitated. You're supposed to be provided services and given those things that you need so that you can come out and rejoin society successfully. So prison is not to punish people. The separation from society is the punishment, and that's the entirety of the punishment, or it's supposed to be. And unfortunately, we've had some Supreme Court justices in the past. Justice Scalia announced in a decision at one point that prisons should be ugly. And he said that in a majority decision that ruled against prisoner civil rights in a number of ways. And so, unfortunately, we have had people that do subscribe to that point of view, but it's a wrong point of view, and it's wrong on many things, like Stacy had said. So yeah, that's definitely a big issue. Let me go to this. There was a lot of testimony today, and in prior episodes, the last two episodes, I've really focused on trying to talk about, general legal principles that were occurring in a trial and tried to break those down into more easy to understand ways so that we could understand when we're listening to the trial what is actually going on and what, what those machinations are that are happening inside the trial. There's one more that I want to talk about because there's some issues that came up regarding some of the witnesses. And this is a legal rule. It's in the rules of federal evidence. It's and in most state rules. It's called the Rule of Exclusion. Julie, can you tell everybody what the Rule of Exclusion is and what it's for?
Sure thing. Before I do, I know that at some point in time, Jimmy needed to dip, and I want to make sure that he leaves on time and gets a proper farewell, if so.
Yes.
We good?
Yeah, Jimmy. Yeah, if you've got to leave, Jimmy, that's true. Jimmy might have had to leave early.
I can hang for 15 more minutes if there's any questions for me or that I can answer. You can toss it to me next, but thank you.
Oh, thank goodness, because I want Jimmy to follow up on this point. So the exclusionary rule, you can the rule of exclusion, different than the exclusionary rule, which of course deals with evidence, is this idea that witnesses don't get to hear each other testify. Because if somebody was to hear what one witness said, potentially they could change their testimony, they could change their story, et cetera. That being said, there's always some exceptions to it. So, for example, the party gets to stay and hear everything, whether or not they get to testify. You can also typically designate someone who gets to hear the entire trial from start to finish. I know it came up because a witness, and maybe Jimmy can help clarify for all of us, a witness liked one of your tweets when they shouldn't have been watching anything about the trial, is my understanding. Did I get it right?
Yeah, he retweeted me. And so it wasn't a quote tweet, just a good old-fashioned RT. And I think I had just said something like shamelessly linking to my article, and it was an article about... I think it was when the correctional officer or the deputy warden talked about how there was like one person responsible for 6 control rooms, which meant that 5 clusters of incarcerated people were not being monitored in any way at all. So, I think, yeah. And they really went after the attorneys, or Judge Silver did, right? She was like, oh, you should have told him, you should have warned him. But then, I think once Judge Silver realized what the extent of what he had done, then she said, I think her words were like, well, I'm not likely to exclude based on this action, or whatever. But yeah, I felt bad.
Yeah. So the rule of exclusion means that when witnesses aren't going to be there, they can't listen to other people testify, so they can change their stories, and it's just a real basic rule. But I think we also had a deputy warden that might have been in there for some testimony. I know that I think Travis Scott, because he kept getting bumped last week, was in there when I had gone down and attended the meeting. He was in the jury box watching expert witness testimony. And was not taken out. But then there was other witnesses that were excluded from there as well. So, is there a reason, Billy? Is there a reason why that you know of that certain witnesses will be excluded and certain witnesses won't?
Well, so parties, first of all, parties can be there the whole time, even if they are also witnesses. I recognize that many of the parties on the plaintiff side, so on the Parsons side of the equation, are technically still plaintiffs. I don't know how many of them have testified. Many of them have long since left the prison system, and as we all know, unfortunately, Mr. Parsons himself is no longer with us. But on the defense side, the main defendant is the head of the corrections system, Mr. Shin, but he's actually sued in his official capacity. So he's actually sued as if he's the human embodiment of the state government. So essentially the state government is the defendant, although we say it's against a particular person. In essence, the state is the defendant. So I'm not really sure how that's treated. Does that mean that any, I've not been watching the day-to-day proceedings, so I don't know if that means that any of the employees of the State Department of Corrections has permission to be in the courtroom at all times, even if they are intending to later be a witness in the same trial, because they are kind of an employee of the party, an employee of the defendant. I'm not sure how that works exactly.
I got you.
I have heard that some of those people are serving kind of as Director Shin's emissary or representative or whatever. So that was the reason that they were allowed to be in the court, and then they're... also end up testifying.
Yeah. Yeah, and that was a concern, and that was one that came up from one of our team members that were watching the trial, and they were concerned about that because obviously you don't want people tailoring their testimony to a prior witness, and that's a big deal. Okay, great. At this point, I'm going to go ahead and turn it over to Deb because Deb has got the questions that we've aggregated over the last couple of weeks and then some new ones. So I'll go ahead and turn it over to Deb. And Deb, go ahead.
Alrighty. Well, thank you all for being here. We really appreciate it. So let's start off with another global question, and that is, what is the desired outcome of the trial? What would be a win for the people who were incarcerated?
I'm desperate to answer this question because I had the same question on Tuesday night, and it was my privilege. I'm not going to tell you which attorneys, but I got to sit with some of the attorneys that are out there litigating the case, and that was one of my questions. What does a win look like? And in this case, it sounds like the end game or the best possible end is that the state prison healthcare system gets placed under receivership, which means that an outsider would essentially be in control, would be in charge of compliance, or apparently, as we call it, partnerships. I've got a whole glossary, y'all, of all of the words that DOC doesn't know the definitions of that I'd love to cover this evening. But apparently partnership is part of it, right? Because nobody ever is the boss. Nobody's ever in charge. Nobody's ever accountable. They're all partners. I'm sorry, I got on my soapbox real quick. But to circle back, receivership sounds like it is the goal. Now, that's still not going to solve everything. And that was my follow-up question to them. What do you do in instances like Mr. Muhammad's, when you're hearing about these guards who are quite literally egging on self-harm and self-injury behavior? Like, what do you do then? And the answer is that we need a better head of the Arizona Department of Corrections. So #FireShin is now a thing. Yeah. Or is again a thing? That's not fair. Again a thing.
It is again a thing. Yeah, and to build on that a little bit, it's we have an issue. So we have to think that using the court system is the final option, right? It's the final option, right? That means that we have not been able to resolve issues through the legislative process. That means that we don't have an administration or a system that is actively doing what they're supposed to do. And the ultimate, when there's that level of intransigence by the state, that requires court intervention. And that's where we're at. We're at the last stage here. And the problem with it is, in my mind, and this is something that I did have a conversation with Julie about, which is if the court takes the Department of Corrections healthcare system into receivership, and let's just say, and that means that the court hires a receiver, and that receiver is responsible only to the court for the duration of the time that the court has the Department of Corrections in receivership. The federal court does not want to be in the business of running prisons. That's not what they do. There's federal laws. The Prison Litigation Reform Act tailors some specific issues regarding what the courts can and can't do, and narrows these things. The problem that we have, though, is if there's a finite amount of time, whether it's 5 years or 10 years or 20 years, that the court would have the Department of Corrections healthcare system in receivership, we still have a privatization statute out there, right? And so the second receivership ends, we still have a statutory mandate from the Arizona legislature mandating the Arizona Department of Corrections use privatized healthcare. So from my position, we also have to have a legislative solution. We cannot continue out just waiting for the courts to fix our problems. We have to look at this legislatively, and that's exactly what we're on the ground at ATAC doing. But there's a lot of people looking at this, a lot of people from both sides of the political aisle looking at the Department of Corrections and trying to figure this out. But one of the things that we absolutely have to do is we have to get rid of that privatization statute, because it is such a perverse statute, and it incentivizes non-care. It gives them all the money up front, And it says if you treat anybody, that's coming out of the money we just gave you. So we can't have a system like that, and that's going to require a legislative solution. So the court is just, in my mind, it may be a long temporary, but it's a temporary fix nonetheless.
Well, the court certainly could declare that statute unconstitutional. I don't know if that's at issue in this case. I don't know, but it seems like it would be necessary prerequisite to, any kind of a receivership system, because obviously if, the federal government can't provide constitutional care via privatized system, and they've decided that the current system of privatized care is unconstitutional, that's an irreconcilable difference there. So something's got to give. That legislation has to be gotten rid of one way or the other. And this court certainly could do that.
I mean, I guess it would be in effect nullified for at least a period of time if it wasn't outright abrogated, right? Billy, it looked like you were about to say something on that.
Well, just the privatization aspect seems to be the core of the problem here. It's the profit motive in healthcare. So they're motivated to deny constitutional care. So you're never going to fix it until they turn off that fire,
Yeah.
No, I think on that privatization statute, that would be a very high, a very tall order. If our federal judiciary failed to strike down SB 1070 a decade ago as facially unconstitutional, I think it would be even harder to strike down the privatization law, just because it's much more attenuated from the constitutional harm. But the question I was going to ask, that kind of raised a question in my mind, and this is a genuine question I don't know the answer to. Is there any talk about a possible remedy of ordering a depopulation of the prison system if according to Jimmy's recounting of the week's testimony, that understaffing is endemic and leadership team after leadership team has continually failed to fix that particular problem? It doesn't seem to be a problem unique to COVID. Is that a discussion? I know that in the Prison Reform Litigation Act, there is a kind of a obscure provision that allows a panel of 3 judges, kind of a special panel to do that. But I recognize that may not be what's being requested here.
Well, that is what happened in the California case. If somebody can remind me, it's the same attorneys, the same groups that, and they ended up going to the U.S. Supreme Court and getting them to order California to release prisoners to relieve the overcrowding conditions.
I think that there's a distinguishing element there, though, and in talking to some of those attorneys, the California Department of Corrections was at 120 or 130% capacity during that lawsuit, and that was directly related to the absence and provision of health care, from what I understand. So there's a direct nexus between population levels and the health care provisioning, in my mind, in my memory. And I don't know that we have that extant here in Arizona. We have just reduced our population by about 6,000, 7,000 individuals out of the Department of Corrections over this period of COVID. So we're at 36,000. We've been up to 44,000. So I'm not sure if overcrowding is even being bantered as a source of the issues. I think that the issues is just administrative neglect, privatization, and some other ones. But I don't know if anybody's heard that. Jimmy, Julie, have you heard anybody talking about depopulation at all? Yeah, I haven't either.
I mean, back in the worst of COVID, it seemed like they were really hesitant to even acknowledge whether Shin or Ducey had that power. I mean, it seemed like they did. Mm-hmm. But so even in the worst of those circumstances, it was like not even on the table where we're going to think about it. So I can't imagine it being discussed again.
Yeah, I do remember a number of organizations were looking at it at COVID, and we're looking at it legally. And I don't know if anything manifested from that at all. Okay, great question. Deb, what do you got up?
So is the judge going to base her decision on the lack of meeting the stipulations in the original settlement, or is there a different standard that needs to be met in this trial?
We're working from scratch, is my understanding. So the judge during the summertime, basically what we call sua sponte, kind of spontaneously, without any party necessarily requesting it, made the decision to set this trial in November, precisely because, if I understand correctly, she was frustrated by the perpetual failure to comply with the years old settlement or consent decree. And so in the order, she specifically, ordered the parties to treat it as a trial, as if there hadn't already been, litigation going on for almost a decade, basically treating it as the first trial. And genuinely speaking, it is the first trial in this case, even though it's kind of odd to say that, but it is the first original trial in this case, despite the fact that it's been going on for 7+ years.
Mm-hmm.
And this also goes to, I think it's Evidence Rule 706 that says that you can't bring up settlement negotiations to prove the value or the merits of the case. And so that the stipulation was a settlement agreement. And so in keeping with that, I think that the judge is saying you can't use that as evidence of the merits of the case. So I think the answer to the question is no, you can't use their failure to meet the stipulation as evidence.
Right. It's in my mind too. It's hard to believe that the judge. The one thing I keep going back to is when the judge ordered the removal of the settlement order and set it for trial. The vacation of the settlement order and set it for trial. And the language that she used in that order to me was I thought it was remarkable. And the attorneys on this panel can disabuse me of that notion, but I thought it was pretty remarkable. And at one point, the judge was even talking to the taxpayers, saying, this is you're paying for this. Basically, I'm summarizing or paraphrasing, but I don't know how the judge. I think using the stipulation and those settlement agreements, and you're right. There's that rule regarding the negotiations of the settlement agreement, but at the end of the day, how does a judge remove that kind of vehemence from her mind and move forward on a decision? I can't see that there would be a complete bifurcation of that moment in time and at the end. But attorneys, do you want to comment on that maybe, or?
Well, yeah, there's not really, I don't think there's a hard and fast answer to that. And obviously in our legal system, we have jury trials where there's 12 or sometimes more jurors. And we have bench trials where there's a jury of one, and that's the judge. We tend to trust, when there's bench trials, our system builds in, it's built into the system that we trust judges more than we trust jurors, because we trust judges to bifurcate their minds from the things they're not supposed to consider, block out of their mind, forget the things they're supposed to forget. With juries, we don't trust them, right? We physically remove them from the room if there's discussions about stuff they're not supposed to hear. There's arguments and discussions and fights that can drag out for months among the attorneys. What can the jury hear? What can the jury not hear? And if you've been to certain courtrooms, they actually have white noise machines, so that the juries can't hear if there's a sidebar conversation that they're not supposed to listen to. So we don't trust juries. We do trust judges. When a judge acts as the jury, we tend to trust the judge to separate out in his or her mind the things they're supposed to consider and the things they're not supposed to consider.
Right.
But ultimately appealing, the appeal process, that's ultimately the check and balance, right? If the judge is suspected of considering an item or a piece of evidence that he or she is not supposed to consider, that's what appeals are for. Yeah. And judges hate to be reversed. That's the one thing they constantly have front of mind, is wanting to render decisions that are not going to be easily subject to being reversed.
Well, and also, I'd just like to add that even though you can't use the fact that the defense did not meet the settlement agreement, the stipulations, as evidence in this trial, throughout this process, they've been gathering evidence about what has been happening. And they have, in the past 2 months since the judge issued that order, they've been deciding which witnesses they were going to bring. And so, as we've seen, as Jimmy has told us, they've selected the folks that have been most abused by the lack of compliance with the stipulation to testify to their experiences. And that is absolutely evidence. So the whole point of this is to get to the truth. And, that both the plaintiffs and the defense had the same opportunity to bring their best witnesses. And what we've seen is that the defense just can't bring the facts. They can't, even their best witnesses are being impeached about what's actually happening. So even though they can't use that stuff, they've got plenty of evidence that they've developed along the way that they can use.
And I want to go to this one issue as well. Like Billy had just mentioned, that the check and balances on a district court or any court, any trial court, is the Court of Appeals. But one thing that we should discuss with federal judges is that those are lifetime appointments. So they don't have to go and run for office. They don't need to go glad hand their appointors, or they don't need to go glad hand voters like many state or municipal benches have to do. In the federal courts, once they're appointed, they're there for life. And I think that they're only subject to impeachment. Is that correct? That's the only way that you can remove a judge, is through an impeachment process. So they don't have those same political pressures. And, the federal judiciary is much more protected from those political winds as opposed to you would see in a lot of state benches and that type of thing. So, and not only is this district judge protected because of being a federal district judge, but she's a senior judge with the district court as well, and has been around for a long time and knows exactly what she's doing, and gets to pick this stuff. Jimmy, go ahead.
I was going to say, I have to excuse myself. I have the perfect exit, just a little bit of levity. I wanted to talk about how Judge Silver's been having fun with the fact that it's a bench trial. And today she said, she was talking about something. She said, that will be the instruction I will give to myself, and I will do as I say. She said that. Nice. And then earlier a witness said, I think we're all getting older. And Judge Silver said, I'm not. I just want to get that on the record. And everyone laughed. So
nice.
She's kind of trying to keep it loose a little bit too. Like, clearly is in control, knows what she's doing, but I was trying to add a little bit of levity too, which I thought was nice.
Yeah,
Thank
that
you
is
for having
good.
me.
That is good, because those things can be tense. Thank you, Jimmy. Thank you for coming tonight. We really appreciate you, my friend. All right.
So we do have a question in the chat room. What is the day the trial resumes? Because that got a little fuzzy for those of us listening at home, it got a little fuzzy.
And Jimmy was probably the best person to answer that, and he just
That's
left.
what I was afraid of. I think I understood it will be December 7th.
That's what I heard too. So that's consistent with what I had in my mind. So
yeah, they kind of disappeared. So we do have a couple of other questions.
Sure.
So would a mandate for body cameras worn by all medical staff and guards help to stop deliberate indifference? And I'm going to add to this is not my question, but could Judge Silver mandate that?
I definitely agree that they should have body cameras. I'm currently in a dispute because I asked for camera footage from the medical infirmary where the medical encounters happen at the bedside, and there's cameras there. And they said, we don't have any video responsive to that. And I'm like, well, are you telling me that there's cameras there that aren't recording? And they're like, we can't tell you that. So, how am I supposed to know what I can ask for in public records? And so much of the dispute is who said what and who knew what and when. And so when you have access to video for that, it makes it all so much easier to understand what happened. Whether or not that is some relief that could be, I guess that would be up to a receiver to decide if that's part of the remedy.
Julie, did you have a take on that? It looked like you were going to say something.
Yeah, I'm going to be obnoxious. I totally disagree. I don't think body worn footage is helpful for combating any sort of state violence, because the moment you see mandated body worn cameras, the next thing that you see is that they're selectively turned off. Isn't that strange? And then you see legislation passed at our state legislature by people on the Brady list in some cases saying, oh, by the way, U.S. citizens can't ever see it. So I kind of loathe that idea now, although I think politicians should all be forced to wear body-worn cameras that are, live streamed. But I dislike it in the fact that it sends the signal that reform has happened, that everything is okay now. And in reality, the way it actually plays out in the nitty-gritty has been everything less that in almost every instance where we've seen body-worn cameras implemented.
Right. And so again, so what we're arguing is that we're arguing again for transparency, right? This is what we need. We need transparency. And so if we're talking about body worn cameras, or we're talking about video footage over bunks, or we're talking about any of this, what we're talking about is selective transparency, right? When it's good for us, we're going to use it. And when it's not good for us, good luck, right? And that's why we need to have comprehensive, independent oversight of the Department of Corrections, right? That's why we need this. This is why we got to do. We've got to open the doors. We got to open the books. We've got to open those cameras, and we have to have integrity and accountability in the Department of Corrections. And so that's why we work so hard on the legislation that we're working on, because we've got to get those doors open. But I think that's, it's, we see that all the time, and they do have cameras literally everywhere in there. And let's not make any mistakes. These are cameras that can zoom in from a quarter mile away and read the small print on a Coke can. I mean, these are very good cameras, and somehow anytime it's going to go against the Department of Corrections, they just stop working or something. I don't know what happened. It was just the weirdest thing. All of a sudden, everything stopped working. So real selective, Aurora Borealis activity or whatever is happening to cause these electronics to stop functioning. But
it's a lot easier to argue that they selectively turn off the cameras than it is to argue that they need to have them in the first. It's like, if we have them, then we know that they're expected to have them. And if they're being turned off selectively, that's evidence in itself of a pattern. So we'll have to have this argument over beer sometime, Julie.
I'd like that. I mean, I think what you're arguing is that it would be a spontaneous event. That's a new phrase that I learned. A spontaneous event. We use that anytime there's a pattern that is utterly predictable that happens every single stinking day. And at the Department of Corrections, it's a spontaneous event.
Very good.
So do we have time for one more question?
Yeah, absolutely. Please.
Okay. We have a few, but we could do it the next time as well. So I really love this, and you'll probably understand why somebody asked this week. What is considered an expert in the field? When witnesses have publications, does that automatically qualify them as expert?
The short answer is no. A publication does not automatically qualify you as an expert. But as I think we talked about this maybe last week or the week before, the question came up about what qualifies as an expert. I think it's very subjective in some ways. There are court cases, notably a famous court case called Dauber that tries to define what qualifies as an expert witness versus a regular fact witness. Again, expert witnesses, for those of you who aren't familiar, are those who are prohibited essentially from testifying about what they personally perceived. Instead, they're allowed to testify only about their conclusions, their summaries, their professional judgments based on their reading of the record or their viewing of documents. But there's not a bright line rule. Stacy and John and I have been working on a case, for example, where there's somebody who may be an expert who you would not expect to be an expert based on their resume, but they have a certain degree of expertise based on their lived experience. And we believe, the three of us believe, that that counts. Conversely, I don't have examples to cite, but I could see a judge, somebody who self-published a bunch of things, on a given topic and tries to purport that they are an expert in that topic, or maybe has online degrees in that subject matter. I could see a situation in which a judge might say, well, no, I need more. I need to see more why you're considering yourself to be an expert.
Yeah. And it's a thing, too, that I see, I've had a lot of friends that have talked about this, that there's no such thing as an expert. But we have to understand the word expert doesn't mean omniscient, right? Expert just means that they have the level of education, skill, and experience with which that they can speak, about something conclusively and, based on that. And so there's that famous scene, and we brought this up a couple weeks ago. There's that famous scene from the movie My Cousin Vinny, where Marissa Tomei is allowed by the court to be an expert witness because she has years and years of experience as a mechanic, and then she was able to withstand the defense or the prosecution in that case's deposition on questions about her expertise. Now that's pop culture and it's overplayed, but the point of it is, I think, is still valid, which is an expert is somebody that the court accepts based on their education, experience, and knowledge in a particular area. And there's no, like Billy said, bright line definition of that. It could be anything. It's malleable.
So the times you need an expert are when any time you're bringing up something that a layperson would not understand on their own. So I actually used one of the named plaintiffs in the Parsons-Jensen case as an expert witness on prison gang culture and the need for protective custody. And that's something that a layperson would not understand, and something that only somebody who'd lived through it would be able to testify about.
Yeah, that's exactly right. Deb, did you have another quick one? Was there one more quick one? We could probably get one more in before we go.
Well, I don't know how quick this is, but I'll put it out there and maybe we continue this conversation because it tags on to what Stacy was just saying a bit. Is there anything in this trial that spotlights the difference in care based on race, gender, or even type of or level of incarceration? For example, PC versus general population, death row, or life versus termed?
I haven't seen that specifically, and I can tell you that my experience of being in the Department of Corrections for the length of time that I was is, and I wasn't on a PC yard, so I can't speak to that, and I can't speak to certain populations that they were there. But I was all the way from a maximum custody down to a minimum custody, and I was on, I think, 7 or 8 different complexes in about 11 or 12 different units, and that included a couple of out-of-states. And what I saw is that everybody was treated the same, crappy. Nobody got anything, in there you were wearing, it's not black, white, brown, those type of things as far as the officers are concerned. It's whether you're brown or orange. Brown meaning the correctional officers wear brown uniforms and inmates wear orange uniforms. And so to that end, it was like that. Now, I think that there would be some conversation, and we have seen that relative to those people that are in high custody. We do know that there are a number of reports, consistent reports from numbers of people over periods of time where these people had no connection to each other of abuses that are happening in the higher custody units. And the reason that those can happen is because those inmates are generally constrained to living by themselves in a single cell. There's no witnesses around, and so they're a much easier target. They're locked down all the time. And certainly we've seen that testimony with many of the people that have testified regarding mental health issues. Mr. Muhammad, for one, suffered for years at the hands of the Department of Corrections. And so certainly we see that. To me, it's more about what's the level of energy or that an officer has to put into a particular issue is more dispositive than, other characteristics. Meaning, are you a troubled person? Are you somebody that I perceive as being a trouble for me? Then you're going to get, the short end of the stick. That's for sure. But they were pretty much across the board. I mean, Stacy, Billy, and I work in a law firm that working for Stacy. That's all we're doing is prison civil rights cases for the most part, and it's everybody, right? I mean, Stacy, Billy, I mean, it's everybody, right?
Yeah, I think in terms of racial disparities, that's probably outside the scope of tonight's discussion, but I think probably all of us would agree that there's obviously very much disparate impact on who ends up in the state prison system, socioeconomically, racially, etc.
Right.
But maybe what I'm hearing and what I'm learning from the law practice in this field is that, and also I think Haley just posted something in accord with this perspective from her husband's experience, that everyone is treated equally bad, and perhaps with the exception of the close custody, which maybe is slightly worse, but perhaps is not dependent or correlated to race or socioeconomic. And many of us know some individuals who are in the state prison system who on the outside are quite wealthy, come from higher socioeconomic backgrounds. Fewer people from that group of society end up in prisons in the first place, but once you do end up in that prison system, the socioeconomic differences are wiped away in terms of the treatment you receive.
Right.
Although, of course, there are prison accounts, right? So
Right.
How much resources your family has on the outside allows you to have more resources on your prison account, your prison monetary account.
Yeah, it certainly is. And you see it in other places too. Stacy?
Yeah, well, I have a couple of clients who actually have a lot of resources, and one of them has paid another attorney a lot of money to fight a case for proper pain medication, and he just settled that one and didn't get anything. He still hasn't gotten his proper pain medication. He hired me to go after that because after all, years and years of trying to litigate this, still. So even with all his resources, he's not able to get proper care. But in terms of the classification, I feel like the cause and effect is a little reversed there. I feel like a lot of people get diseases and mental health issues from the conditions, from the classification, from being locked down, not being able to exercise, not having a good diet, not being able to, maybe get outside food or commissary, to supplement their diet. And then, if they, so I feel like the higher classifications may be suffering worse, on both ends because they're more likely to get some severe issue in the first place and then less likely to be able to treat it.
Yeah, that's very consistent. Okay, what an excellent conversation we've had tonight. This was really, really good. I so appreciate each and every one of you, Deb, Billy, Stacy, Julie, and Jimmy, who's has gone. I can't tell you how much I appreciate these conversations. We will be back again in December when the trial picks back up. We'll resume this again and keep moving forward. I just want to remind people of a number of events that we've got coming up with ATAC. We have, there's so many. Let me get them all right. Deb, help me if I forget anything. Let's see. We're going in order. So we have Tuesday night. Tuesday night we have a panel again, Facebook Live, and hopefully we'll actually be able to do it on Facebook Live with two former correctional officers, former CO3 Mindy Krasinski and former CO3, CO4, and ADW Brian Radford, who is now running for office in LD11 on the Democratic side of the aisle. They will both be joining them, and between the two of them, they have over 45 years of collective experience in the Department of Corrections, and I will go ahead and moderate that. And that's going to be an incredibly informative conversation, and it's just not something that we see very often in this space. Is the people talking to the correctional officers, and they have a ton of incredible information to bring forward, and they are just as much about oversight of the Department of Corrections as we are. So that's going to be an extraordinarily interesting conversation that we have on Tuesday. On Wednesday, we are premiering the first of an incredible series that our mixed media content specialist, Haley Worrell, that was mentioned earlier by Stacy, has produced this incredible video series that we will be rolling out every 2 weeks, and we're premiering the first one this Wednesday night, also on Facebook Live. I'll have a Facebook Live, and we'll have a conversation between Haley and I, and then we'll show the first episode of the We Are Just One Family series. And so that will be out Wednesday, Facebook Live, ATAC Facebook Live event at 6 p.m. That'll also be Tuesday, Facebook Live at 6 p.m. For the panel with the two correctional officers. Subsequent to that, in December, we have another panel that we'll be doing with Representatives Walt Blackman and Representative Diego Rodriguez, where we will talk to them about oversight and upcoming legislation on that. Deb, what have I forgotten? Have I forgotten anything?
There's one thing I'd like to add, and that is
Sure.
that November 30th, we are a 501c3 ATAC. We're young, and November 30th is, what is it? Tuesday Gives Day?
Right.
Across,
Arizona Gives or Tuesday Gives or something?
Well, this is not Arizona. This is worldwide.
Oh,
but
there we go.
We are your choice for some extra cash. So please go to our Facebook page, and you'll find a way to donate.
Yes. And our website, we'll have information on that on our website at aztracco.com, aztraco.com. You can find us there. You can find us on our website. We will post this video. We did record it, and we will post it on Facebook here right after this, and it'll also be available on YouTube. All of our videos are on our ATAC YouTube page as well. Please like and subscribe to our YouTube page so that we know who you are and you get notifications when we do these postings. Again, I want to say thank you so much to our panel, and I want to say thank you to everybody that joined us in a Zoom meeting tonight. Very sorry there was something happening with Facebook and the live streaming would not work at all, but we really appreciate you sticking with us, supporting ATAC and our mission, and working on this extraordinarily important issue where we got to get independent oversight of the Arizona Department of Corrections. Thank you so much again, panel. We will see you again in December, and thank you all for joining us tonight, and you all have a wonderful, wonderful week.
Good night.